All right, we're going to answer the question, if I patent an intermediate product or a subcomponent, could that be an infringement of a final product or system? Hi, I'm JD Houvener, patent attorney, owner here at Bold Patents Law Firm, also the author of Bold Ideas, The Inventor's Guide to Patents. I've helped inventors for over 10 years now and helped them earn over 500 patents. I'm excited to talk with you today and help you work through this question about subcomponents or intermediate, call them, patents. And if that's what you're going for, the question here is that potentially infringing other patents that are out there on a complete or final system? Well, the quick answer is yes, it could. You have to be careful. And this is part of the difference between getting a patent versus being able to sell it freely in the market. Those are two different things. Let's take them one step at a time. So achieving a patent protection for a component or a subpart of a system is definitely doable. In fact, happens all the time. Most patents are issued today, I would say between 70–80%, are improvements or incremental changes and efficiencies of existing technology. And usually those are not the full system. In other words, they're not the end final product that would get sold to the customer. They're a part that will, maybe it's a different locking mechanism, a different attachment or fastener or material that can be used for final design. The end market ready product may be controlled under a fully different set of utility and design patents. So the big question you've got to ask your patent attorney is, as you get ready to sell or go to market or even license your product, you should ask the question, can I sell this complete final market ready design and sell it into the stream of commerce without risk of infringing other patents? And this is also called a freedom to operate opinion. Am I free to operate? Am I free to sell my product without the real risk of being sued by other enforceable patent owners? And it's a different question because you may have a solution, an innovation within, let's do an example within the automotive industry. You've come up with a brand new way of eliminating drag on the back of the car by adding specific features on the hood, on the top of the car. And it's little tiny fins that will separate the laminar flow and reconnect it, so it reduces drag. You probably have seen some of these, right? These little tiny little outposts, and they actually do. That's what they do. They interrupt the drag flow and will allow that reduction in drag, and so therefore more aerodynamic, less friction. The car can go faster. The cool thing is, those will save a bunch of fuel efficiency. It could also help the car perform faster if it's a race car. But you cannot sell a brand new race car on its own if it's some other design that's owned or patented by another company. And so that's the catch, is you have to be able to license your innovation to the manufacturer of the automobile, and they can sell the whole package together once they have the rights from you. You're not likely going to be able to go manufacture your own vehicle unless you come up with a new design for the vehicle that, again, doesn't infringe any of the rights holders. So I hope that helps you kind of understand and appreciate subcomponents versus final design, and how you've got to check both. Even though you've got a patent, that doesn't mean you've got the right to sell your end product without fear of potentially infringing others. Hi, everybody. I'm JD Houvener, owner and founder here at Bold Patents Law Firm. Have an awesome day. Go big, go bold.